Good morning, everyone.
Morning.
Can you hear me okay?
Yes.
Yeah, everybody can hear me. We might want to close those doors. Let me get those. All right, so anyone that hasn't signed in, we have a sign-up sheet up front. There's a packet of information, binder with all kinds of different information in it. I'm not going to go through each one of those different pages in there. It's just sort of for your reference, but we'll kind of reference them as we go throughout the day. My name's Dan Leffler. I'm Chief of Staff of the OPBA. Thanks for coming to our semi-annual, biannual would be every 2 years. We do seminars throughout the state to kind of give an update, a legal update as to what's going on in your world and issues that are affecting law enforcement. So I appreciate you coming. I think I have maybe a 15-minute break scheduled in the morning. I don't have other breaks scheduled, but it's very informal. If you have to go out and go to the bathroom, or if you need coffee or a donut or whatever, feel free to get up and walk around. You're not going to offend me. So, and are there police officers or dispatchers, corrections officers? How many are police officers? Corrections or dispatch? Okay. Later in the afternoon, when we talk about some of the use of force stuff, it might be kind of boring for the non-law enforcement people, but I'll try and keep it interesting, or if you have questions. And the other thing is, if you have questions while we're going through this, feel free to ask the questions. We have a microphone up front if anybody needs the microphone. So it's very informal. I'd prefer that it be a conversation style and answer the questions that you guys might have rather than just standing up here and talking about stuff. And you're probably going to get a large dose of me. We usually try and break it up with different attorneys doing different topics and stuff like that, but unfortunately a couple of our attorneys had things scheduled and they had to attend those, so you're stuck with me for most of the day. So I want to start off real quickly by talking about Janus, and then when we get to the PowerPoint, we'll talk about Garrity and Weingarten. As most of you probably know, their most recent U.S. Supreme Court case in Janus versus AFSCME was just released a couple months ago. And I'm not going to go through all of the legal arguments and what that means, but essentially what the court had determined is that anytime a union engages in collective bargaining, that constitutes free speech. And that implicates the free speech under the First Amendment. And so as the Ohio Revised Code and what the previous case law said is that the union, in order to negotiate the collective bargaining agreement for all of the employees, could collect a fair share fee, what they call a fair share fee, from non-members, which people that decided for whatever reason not to join the union. We could collect the fair share fee, which was the amount of money that it cost to collectively bargain in the state. And for us, that's usually a very small difference between the fair share fee and what the regular fees were. Under the previous case law, Abood, it said that we had to deduct any costs for political activity, religious activities, non-collective bargaining things. So, this seminar, the cost of this seminar would be excluded from the fair share fee. But our dues every year usually comes out to about 90% of our funds go to collective bargaining. So our dues are $36 for 2018. I think our fair share fee was somewhere around $32. So almost all of the money that we generate goes directly to collective bargaining. We don't do any political activity. We don't contribute to political candidates. So it really didn't have a major effect on us, but essentially what the court had said is that we're no longer allowed to collect a fair share fee, because those members or those employees that elected not to join the union were exercising their First Amendment right not to pay the fair share fee. That's basically what it comes down to. As I said, I'm not going to go through sort of the court's analysis and how they got to where they were. But as a practical application to the OPBA, since the case was decided, we've had maybe 2 inquiries to decline to pay or to not join the union and decline to pay the fair share fee. It's actually, sort of improved our efficiency a little bit by going out and getting green cards and membership cards and people to join. And we've actually, once we sort of did the audit of all of our members, we've actually picked up about 200 members just by them being on the payroll but not paying union dues. So for us, it's been a good thing. I don't really have much more to say about it unless you guys have any particular questions.
What should we look up to read further on it?
Well, you can probably do a Google search of Janus versus AFSCME. There will be the actual Supreme Court decision, which again is sort of convoluted and, in my opinion, doesn't reflect exactly what the current state of the law is. But they're the Supreme Court; they make those decisions. But there will be a lot of other articles and comments about what it means and how it applies and all that kind of stuff. One of the questions that came up last week, though, is, how does this affect me, or what is the OPBA going to do for non-members that might be in your unit? I don't know if you're a director of your unit or a representative or something like that. For purposes of representation by an attorney, the OPBA provides an attorney for all of your collective bargaining, for disciplinary matters, for criminal defense, for civil defense. You get an attorney paid by the OPBA for all of those different things. Under the bylaws, we provide criminal and civil defense, but that's not required as part of our collective bargaining obligation. So you're not going to get the criminal and civil representation. That's fairly clear. The sort of gray area comes in when you're talking about the disciplinary process. Typically, we would provide the attorney that would, as soon as you get notice that there's potential discipline, you can call the OPBA and the attorney would talk through what happened, what's going to be the procedure, what's going to happen next. We'll come out to the internal interview. If there's an interview process, we'll go to the pre-disciplinary conference. So we sort of walk you through the whole procedure. And in this circumstance, we probably would not provide the attorney for the internal interview and the pre-disciplinary conference. The gray area comes in is under the collective bargaining agreement, because we have just cause provisions, do we have an obligation under the duty of fair representation to provide representation during that sort of process, during the grievance and arbitration process? And that hasn't been worked out yet. We'll have to wait to see how the Ohio Revised Code is amended based on the Janus decision to see what our obligations are. So for right now, just what I would suggest is contact us. We're probably going to evaluate it on a case-by-case basis to see what the circumstances are. If it's a use of force situation, you're out on the street and something happens, and you have 2 or 3 members, or maybe it's just 1 member that is involved. Typically, the OPBA attorney isn't going to have the audit in front of them. They're not going to know who's a member and who's not a member. So it's our organization has made the decision that we're going to send an attorney out for all use of force situations. So whether the person involved was a non-member or a member, we're going to send an attorney out. We'll advise them of their constitutional rights, the typical procedures that we would go through in a use of force or a shooting incident. And then after the fact, we can come back and evaluate, is this person entitled to representation in the criminal or civil process and that kind of stuff. So we are going to send somebody out. So don't hesitate to call us. It's the goal of the organization to represent law enforcement to the best of our ability, and we think that that's an important thing to do. So we will continue that aspect of it. Okay, any questions? All right, so moving on to Garrity and Weingarten. Has anybody attended our seminars before? Okay, well, you might have seen this before. I think I had it up here 2 years ago. So So this is a scenario. Officer A is ordered down to the supervisor's office. He enters the supervisor's office and he starts asking him questions about his use of sick leave. And he said, hey, there's a rumor going around that you use sick leave, but somebody saw you down at the Indians game during that period. So why don't you tell me what happened? In fact, Officer A took his daughter to the doctor's office. In fact, he has a note, and he provides the note that says, yes, we were here at this date and this time. But sort of during the conversation, in an offhand comment, he says, the last time I took any sick leave around here was for my wife and I's anniversary. So the supervisor immediately places Officer A on paid administrative leave pending further investigation. The supervisor goes back and looks at your Facebook page and finds out, yes, you were actually on your anniversary at the time that you were taking sick leave. So typically probably not a big deal, although use of sick leave for reasons not approved in the collective bargaining agreement is considered theft in office. We have had officers, dispatchers, we've had employees that have been charged criminally for theft in office for doing that. So the question is, does this violate Weingarten or does it violate Garrity? Does anybody have any opinions, thoughts? Does anybody know what Garrity and Weingarten mean generally? All right, so we'll go through those standards as we go through this, but generally it is not a Weingarten violation, and in my opinion it would not be a Garrity violation either. And we'll sort of talk through that. So the rules that I'm going through are cases. Weingarten and Garrity are both U.S. Supreme Court cases. Garrity was from the 1960s, I believe. Weingarten was from the 1970s. But those are U.S. Supreme Court cases that generally talk about what your rights are. In the collective bargaining agreement, if you have provisions in your collective bargaining agreement that talks about what is required during the disciplinary process, that prior to questioning they have to provide you with an OPBA representative. You can't be required to say anything until that representative is there. Everybody's collective bargaining agreement has different language on that. But generally speaking, whatever your collective bargaining agreement says, that is the procedure they have to follow, regardless of what the case law or anything else in the background says. So if your contract says prior to any questioning you have the right to an OPBA representative, you have the right to do that. You don't have to ask for it, you don't have to assert it or anything like that. It's just guaranteed under the contract. Recently we've started to try to get language in that says prior to any investigatory interview, employees would be guaranteed Garrity or be compelled or required to give a statement. And I'll tell you why that's important as we get to the Garrity portion of it. But again, if your collective bargaining agreement has language, that's what the employer has to follow. So what is Weingarten? As I'd mentioned, Weingarten is a U.S. Supreme Court case. And more accurately, the question is, when does an employee have a right to union representation? So the case from 1975 dealt with the National Labor Relations Board case, which is very similar to Ohio's SERB. SERB is actually, the State Employment Relations Board is mirrored off of the national regulation. So it applies in Ohio equally under the same standard. But they looked at when can an employee refuse to submit to an interview without a union representative. And the deciding factor basically is where the employee believes that that could reasonably result in discipline. That's the standard. So an interview is a confrontation conducted by an employer or a representative of the employer in which the employee reasonably believes could result in discipline. So in the scenario where the employee was called down to the office, obviously that's a confrontation. You're being called down there for a purpose other than just to say, hey, good morning, how was your day, right? The question was in your mind whether that could potentially result in discipline. If they just want to call you down and say, hey, we noticed this report didn't have these facts or there was missing this or something like that, that's generally not considered to be disciplinary. And as we go through this, they'll talk about day-to-day sort of interaction, if it's instruction, if it's, sort of how to improve what you're doing on the job, that kind of stuff. That doesn't entitle you right to a union representative. It's only where there's potential for discipline. And so, as I'd mentioned, 4117 under Ohio mirrors the standard for Weingarten. And here's basically what the requirement is that the interview was investigatory, that the employee requested the presence of a union representative, and that was denied, that the employee reasonably believed that the interview could result in discipline, and the employer subsequently compelled the employee to continue with the interview. So, to me, the most important part about Weingarten is that the employee has to affirmatively request union representative. If you're called down and you start talking to the supervisor and he says, hey, we're looking at some type of discipline here, and you sure you want to come down and talk to us? And you say, yeah, no problem, it's cool. You never assert your right to a Weingarten, there is no violation. You have to affirmatively, or if you're a director that's in your department, make sure that your employees know you have to ask for it. If you don't ask for it, it's not a violation. And so this is where it talks about the rule doesn't apply to the run-of-the-mill shop floor conversations or daily instruction or things that your supervisor might say to you. And obviously that's the most important things, where the employee requests the representation. The employer could advise the employee that they will not proceed with the interview until the union representative gets there. However, then they would make their decision on whatever it is that they're looking at based on the information that they have at hand without your input. And this is sort of a lot of employees view this as some type of a threatening tactic or something like that. But it is the law, and they can do that. So basically they say, hey, if you don't want to participate, you want to give us your side of the story, then we'll just take the information we have and we'll issue discipline based on that. And then a lot of times the employees, wait a minute, I want to tell you what happened, So they have the right to do that. There's nothing wrong with that. That wouldn't be any type of unfair labor practice or anything that the employer had done. The representative is there only to assist the employee. They can't answer questions for them. If there's some confusion about a question, or if there's a fact that doesn't make any sense, you can try and clarify exactly what it is that that confusion is. But you can't answer the questions for them. You can't interrupt the interview. You can't tell them, no, we're not answering that. What I tell people, and if you're a director or somebody that's acting as the union representative, a lot of the stuff has to be done prior to getting to that interview. So what I would do and what Yvonne would do, and I don't know if everybody knows Yvonne Trevino, she came in. But what we do under the circumstances is that we take the employee aside from the interview, say, hey, this is what they're alleging, what happened? Can you tell me what happened? What are the facts and circumstances? And then we can sort of figure out, is this something that could result in discipline? Maybe there's something else there that they didn't think about and we didn't think about, but we can figure that out. So a lot of the stuff is done prior to the interview. And we can say, okay, if they ask you this question, this is how you can phrase it. We're not, changing the truth. We're not shading the truth. We're not changing the facts and circumstances. But there is a better way of phrasing things that we can sort of help you with and go through, and then that will alleviate, hopefully, some confusion or what the employer ultimately is going to do. So once you get into the interview, though, you're sort of hands off at that point. There's not a lot that we can do at that point. The union representative also does not have to be an OPBA attorney. It can be somebody else at your department. So if there's another patrol officer, or particularly if there's been a director or a steward in the past, they can say, fine, you want your representative, we'll go pull Officer B off and he's going to be your representative. That is permitted as well. So a Loudermill hearing, what we call, generally in our contracts, they're called predisciplinary conferences, but Loudermill is another U.S. Supreme Court case. But during that process, you are not required to have a representative, or you can't require to have a representative. So during the due process stage, which is the predisciplinary conference, all they have to do is advise you of what the potential charges are, and then give you an opportunity to explain those. They don't have to provide you representation, and it's up to you at that point whether you're going to provide any information or not. All right, so any questions about Weingarten and what that means? Okay. So the most important thing, obviously, that you have to ask. Usually the other question comes up is, well, how long do they have to wait until my representative gets there? You know, the standard is a reasonable period of time based on the facts and circumstances. Again, if you look at our collective bargaining agreement, sometimes we have specific language that says, you know, you have 1 hour to get in a representative here. And then in that case, you could call the OPBA and would send an attorney out and they would be there in time. Absent language that has a specific time, then it's generally going to be a reasonable amount. So if you say, hey, captain or sergeant or whatever, I just need 15 minutes so I can talk to my union representative. 15 minutes is probably reasonable. Half an hour is probably reasonable. Once you start getting into an hour or beyond that, you know, then I'd say they probably don't have to wait much beyond that. Okay? All right. So, you know, going back to the Weingarten thing, you would think that that's sort of my scenario where the employee blurts out that they took sick leave and went to their anniversary. You would think that that's sort of that would never happen. Why would that ever happen? This is sort of weird. But if you read the Weingarten case, it is unbelievable to me that a case like that ultimately ends up before the U.S. Supreme Court. So what Weingarten dealt with was an employee at a grocery store. This is back in the 60s. You have to remember this is back in the 60s or 70s. Probably happened in the 60s, even if it wasn't heard until the 70s. But an employee, a clerk at the local grocery store, she was accused of putting more chicken in like the small container. They had two containers, a large container, a small container. She was putting more, the size of the large container, into a small container and was checking out. She was only paying $1.99 instead of $4.99. So they accused her of theft. They call her in, they go through the interview process, and they say, you're doing this, this, and this. She denies it. They have a private investigator actually watching her from that point on. Turns out, you know, she was not doing that. So when they call her back in to say, hey, you know, this is what we found out, you know, she breaks down, she starts crying, and she says, the only thing I've gotten around here is a free lunch. Well, they don't have free lunches there, and they didn't provide any type of food for lunch, and you didn't get time off for lunch. So they started a separate investigation to determine how many times she's taken free lunch. This is what happens. You know, how does that case ultimately end up before the U.S. Supreme Court? But it's an interesting, weird case. And then the other part of it is, a different U.S. Supreme Court case is Garrity versus New Jersey. And generally speaking, Garrity is going to apply, in my opinion, it should apply any time that there's potential criminal activity. And so any time that you are called down to a formal interview or to sit through, you know, if they schedule an investigatory interview, my position is that we assert Garrity on every interview. Because I don't know what's going to come out during that interview. I don't know whether something is potentially going to be criminal or not. I don't know what type of information the employer has prior to getting to that interview. So they may call you down to talk about, you know, why did you go to the Indians game, but then turn around and say, and by the way, we have these 25 Facebook posts that all say you were doing X, Y, and Z. So assert Garrity up front. And essentially what Garrity says is that you can't be compelled to waive your Fifth Amendment right. Everybody in the United States has a Fifth Amendment right to remain silent and not to incriminate yourself. However, the employer, the government, as the employer, can compel you to participate in an interview. They can ask you questions and you can be compelled to answer those questions. So what the Supreme Court is balancing is your right to remain silent under the Fifth Amendment compared to the government's ability to regulate its workforce and to interview employees for purposes of discipline. So the case stems out of New Jersey, and they were looking at some police officers that were doing fixing tickets and that kind of stuff. And in that case, so there was a threat of removal from public office if they did not participate in the interview process. So they said, look, you can either answer these questions right now or we're going to fire you. And so the employees did. They answered the questions. They ultimately were indicted and convicted of whatever the New Jersey statute was for fixing. And then it made its way up to the Supreme Court saying that was they were being compelled to waive their Fifth Amendment right.
And what if an employer, if you invoke Garrity and an employer says that they do not want to do a Garrity, what do you suggest directors do in that situation?
So the standard for Garrity is that you're being compelled. And the other part of Garrity is that you don't have to affirmatively assert a Garrity right. It's different than Weingarten, right? Weingarten, you have to say, hey, I want my union representative. Garrity, you don't have to have any magic language or say, I want Garrity rights or anything like that. The standard is that if the employee feels like they're being compelled under threat of discipline, Garrity automatically attaches. Or we will make the argument, right, at some point in the future, hey, this was a compelled statement, you can't use it in a later criminal prosecution. So in the absence of Garrity, or if you're not being compelled to be there, then you revert back to the Fifth Amendment right. You have the right to remain silent. Anything you say can and will be used against you. All of the Miranda warnings. So you simply could say, fine, then I don't want to participate. And you get up and walk out. Because if they're not going to compel you, then any statement that you give is considered to be voluntary at that point. And all of the information that you give them then can be turned over to the prosecutor for review for a criminal indictment. So, that's easy to say from my world, but you're the ones that have to work there, you're the ones that have to deal with the supervisor, and the supervisor is probably going to, give you the, hey, if you don't want to answer questions and you don't want to go through it, that's fine, then we're just going to go forward with the indictment and we'll see where it ends up. My advice at that point is say, okay, do what you have to do, and I'm not going to incriminate myself. I'm not going to give you information to indict myself. And as the police officers in here know, do defendants probably convict themselves more than they don't? Right? You go out, you ask questions, you ask certain things, they start volunteering information. All of that stuff, gives you more reason to then take it to the indictment or prosecution or something like that. The best, I can never understand why a defendant or somebody who's been convicted of a crime had volunteered to let the officer search their vehicle, right? So you walk in and you're like, hey, is it okay if I search in your trunk? Yeah, man, go ahead, no problem. You go in the trunk and you find like 20 pounds of marijuana or cocaine or something. You're like, why'd you let me search your trunk, Because, generally people want to cooperate, or they think, well, if I say yes, he's not going to do it. Well, we know how that usually turns out. So if you are the one that's being looked at, don't give them any more information than what they need. That's my advice. But obviously you have to work there, and that's a judgment call on your part. So what the Supreme Court generally said is that the option to lose your livelihood or to pay the penalty of self-incrimination violates basically Miranda. So Garrity protects any statements that are being compelled from use at a later criminal, basically a later criminal trial. So there's going to be some nuance and some minor details here. It can be used for purposes of discipline, even though you assert Garrity and you say, hey, I'm going to, being compelled basically to give this statement or to answer questions. They can use that for internal administrative purposes. They can discipline you for that. They can terminate you for that. But they cannot then turn it over for a later criminal trial. And when it talks about later criminal proceeding, Generally what that means is that if you end up going to trial, they can't use that information. Now, as law enforcement officers, you probably know that there's the fruit of the poisonous tree. Let's say I take those statements that you gave me, I give it to the prosecutor, and the prosecutor says, well, I see that he said X, Y, and Z. Now we're going to investigate those facts from a different perspective, right? We're not taking your statements, but we're going to do an independent investigation to find out whether those are in fact true or not. Did they gain that information independent of your compelled statement? What I'm going to tell you is that's sort of a gray area. Just because they turn it over to the prosecutor doesn't necessarily amount to a Fifth Amendment violation. If they later indict you based on your statements and the information that you gave them, then I think yes, at that point, you might have a Fifth Amendment violation. Certainly if you go to trial and you're convicted, all of that, that is exactly what Garrity is meant to protect against. So just because they get the information, they turn it over to the prosecutor, at that point doesn't necessarily mean anything, especially if the prosecutor says we're not going to indict. Then it's sort of moot at that point. And some type of direct threat. Again, it doesn't have to be, hey, I'm compelling you, I'm ordering you. If you're called down to the office and you have, the chief and 3 sergeants all sitting there, and somebody closes the door behind you and is standing here like this, looking at you, is that enough? That's not a direct threat, but could it be an indirect threat or compulsion? Arguably, and then it's Yvonne and I's job to sort of argue that point going forward. But so a direct threat is obvious saying you're compelled or you're being ordered. So then there are circumstances where there's absent direct threat. You might have a policy in your handbook or your policies and procedures that says you are required to participate in any type of internal investigation. Is that an indirect threat? If you don't do it, are you then violating the policy, and then they're going to violate you for the policy? So, those are all the different things that courts look at and have analyzed. There's no clear answer. I can't tell you, how the case is going to come out one way or another, but there have been cases where they say, under those circumstances, that was compelled. I've also seen cases on the other side that said just because you followed the policy doesn't mean that Garrity applies. So, and there's another Supreme Court case, Van Gates, that the employee was granted immunity pursuant to in the policies and procedures, it talked about that type of compulsion. And that was protected, but when she later testified at a civil trial, those statements were not Garrity protected. So if you go voluntarily to a civil case and you testify in court, you're not being compelled, even though the employer may say, if you're there defending the employer, that's not being compelled by the employer, therefore Garrity doesn't apply. So just keep in mind, even if you're subpoenaed on behalf of the employer to come in and testify or to give a deposition during a civil case, that's not protected under Garrity. So those are, generally more standards. So basically what it means is that they can't turn it over to use at a criminal trial or to try and convict you. You can be given some type of immunity. The other area where this sort of comes up is in the grand jury. Let's say that you did not participate in the internal investigation, or they didn't compel you to participate during the internal investigation. Ultimately you end up getting indicted, or they call you to the grand jury in order to give testimony. They can compel you to come to the grand jury. We can't prevent that from happening. We can't stop that. Testimony before the grand jury arguably could be compelled, although I think the courts would come out and say, no, basically. So what we usually do in those circumstances, and George will be here later on to talk about, how he advises people during the criminal process. And sometimes we do agree to do that, and sometimes we don't. Sometimes we go up and say, hey, I'm pleading the fifth. This was just an interesting case. Nothing really in particular out of it. But the employee had completed a field report and a use of force report. Was not ordered to, although generally speaking, right, you're involved in the use of force and the sergeant says, hey, do a report on it. You do your report, your incident report, or whatever it is. In this case in particular, they said that was not a compelled statement. All the information that officer put in his field report, incident report, use of force report, all of that was voluntary and not covered. So going back to our first scenario, remember Officer A was called down to be asked about sick leave. So same scenario here, Officer B is ordered down to the supervisor's office. He's asked about, when he took sick leave and whether he went to the Indians game. And the Officer B says, well, before I answer any questions, I think this could be potentially disciplinary, so I'm going to ask to have my union representative there. So they say, fine. Officer B consults with the OPBA. We meet with them ahead of time. We say, okay, these are what the allegations are, what happened. Okay, you have a doctor's note? Great. We'll just give them the doctor's note and we're done at that point. So Officer B denies being at the Indians game, said he took his daughter to the doctor. He has the doctor's note. The interview is over. Officer B gets up and walks out. And there is no discipline, and obviously there is no potential criminal indictment for theft in office. So, in the same scenario, things can go very wrong very quickly. So, you want to assert your right to talk to the union representative, and you don't want to offer any more information than what they are specifically asking you or you're being compelled to give. So, we want to be Officer B. All right? Any questions about Garrity and how that applies? Or if you're a union representative? No? Okay. I don't know what time we got here. I'm going to talk about employee health issues in just a few minutes. We've gotten a lot of the inquiries that we get at the office are about, hey, I'm sick. The employer disciplined me because I was off, or I was ill, or I had some kind of disability. They sent me for a fitness for duty evaluation. All of those different things, come up, and we get a lot of questions about that kind of stuff. So I just wanted to kind of briefly touch on, what can the employer do? What can the employee do? What are your rights under a number of different, there are a lot of different federal statutes that apply to those types of issues. In the packet of information, I think I provided stuff on ADA. So Americans with Disabilities Act, when that applies, what the employer can and can't do. Genetic Information Non-Discrimination Act, which is called GINA for short. I've personally never had a situation of GINA. Have you ever had anything that come up?
No. I didn't even know what it was, to be honest. I don't know if anybody else knows what GINA is.
I don't, I haven't studied it. It's not an area that we typically get into. If there's an issue involving a potential ADA claim or an EEOC claim or a GINA claim, I guess, the OPBA doesn't provide representation for those types of actions. So we have generally people that we would refer you out to that have, specialty in employment law and these types of areas that would be able to answer those. So I've really never had a situation. I think the only thing to take out of this is that when the employer requests medical information in a fitness for duty or some type of situation, or if you've applied for FMLA, they can request medical documentation. They can't ask for like family medical history or any type of, I guess, hereditary background.
I think maybe like that breast cancer gene or
Yeah. Yeah, and so I think the purpose of it was to prevent them from, if you're applying for a job and they look at it and say, oh, this person's got some bad health, we're not going to hire them. I think that's what it's trying to prevent. But it does apply in circumstances where you're an existing employee and they request medical documentation. So anyway, there's a whole packet of information in there. I also included the Ohio Revised Code section and the Ohio Administrative Code sections regarding disability and when those apply. And so just generally I'm going to talk about, what happens in a practical situation, right? And there's going to be a difference about whether you're, injured on duty or off duty, or you have an illness resulting either on duty or off duty. Most of the collective bargaining agreements, I shouldn't say most, probably 50% of the collective bargaining agreements have some type of injury on duty leave provision, which says that if you get injured or you become ill as a result of an on-duty incident, the employer is going to continue to pay you on payroll for a period of 60 days, 90 days, 120 days, whatever the contract says. So, if you're out doing your job and somehow you break an arm or you break a leg or something like that, the employer is just going to continue to pay you until the end of that injury on duty period ends. The question is, what happens if we don't have some type of injury on duty provision, or I get to my 90 days and I'm still not able to go back to work? What's going to happen in that circumstance? Or if this is an off-duty injury that's not going to be covered by that on-duty provision, what happens? I know I have sick leave. I can use sick leave. That's great. But what if I only have 200 hours of sick leave in my bank? Is the employer going to fire me? All of those different types of questions come up. So, as a practical matter, probably the biggest issue that we usually run into, and it's the biggest protection, is the FMLA, Family Medical Leave Act. And what the FMLA says is that you get 12 weeks of unpaid leave, but you have the ability to substitute some type of leave for that in order to continue to get paid. So I'm going to sort of differentiate between on-duty. If it's an on-duty injury, obviously the Bureau of Workers' Comp is your insurance, right? It's your state insurance that will provide you with medical benefits and pay if you're injured. So in the on-duty scenario, once your time runs out, you can transition onto the BWC program. They'll pay your wages. I think it's 60% or 66%, whatever it is. And I think that's non-tax, so they try and equate it to what a normal paycheck would look like. And they're going to cover any medical expenses related to the injury. They are not going to cover any type of family coverage or dependent coverage that you might have. So the other question that you're going to ask is, how do I provide for my family if I'm off work and I'm on a BWC type situation? That's a whole nother aspect that we'll sort of get to later on. But so absent the on-duty injury, if we're talking about off-duty injury, you have 12 weeks of leave. You can substitute sick leave, vacation leave, comp time for that period in order to continue to get paid. If you run out of all of your leave during that 12-week period and you're still not able to come back to work, you're going to go on an unpaid status at that point. And so whatever the balance of the time, let's say you were on sick leave for 8 weeks, you have 4 weeks left of FMLA, you're going to go on 4 weeks of unpaid FMLA leave. Now, in theory, when you get to the end of that 12 weeks of FMLA, the employer could terminate you at that point. Say, hey, you're out of leave, you're out of FMLA, you have no reason to continue on as an employee, so we're going to terminate you. Although the state has stepped in with the disability provision, and again, you have to sort of look at how long you've been there, what your circumstances are when you apply for a disability. But there is a sort of a net there that will protect you. And then the employer wants to do an involuntary disability separation. It doesn't mean that you're being terminated, doesn't mean you can't go back to work. It means that when you recover and you're able to recover and you're cleared to go back to work, you can apply to go back to your previous position. Yeah.
Lack of anything in your contract, our employer has decided in the last 5 years to run your FMLA time in conjunction with your sick, vacation time, comp time, whatever.
Yep.
Yes.
And I can't get a definitive answer if that is allowed or not.
It is allowed, and it's specifically written. The way the statute is written is it says that the employee has the option of substituting leave, or the employer can compel you to substitute leave. So
I know one of my contract negotiations, we tried to, and I think some of the township guys might know this, but we tried to get a provision because the employer did not want to track FMLA and sick time at the same time because there was just so much paperwork. So we tried to negotiate, okay, you run all of your sick time, vacation time, then FMLA would start. Trustees wouldn't approve it, obviously, but even the employer at that point wanted to do it because there's just so much paperwork that's involved. But that is a very common question, and they can compel you to use both, and that happens a lot with maternity leaves during pregnancies and things like that. So,
yeah, and
What happened to me, I just got a letter from our law director saying that, because I was out for 8 weeks, that I'm on FMLA with all my other stuff. I didn't fill out any paperwork for FMLA or anything.
yep. No, they can do it. The issue is that the employer has to have an employer-wide policy. That policy has to be established, and it applies to everybody equally. So they can't go to you one day and say, oh, we're running your FMLA at the same time, but somebody else we're gonna do it differently for somebody else. So if they have a policy, county-wide policy that says this is how we're going to do it, they can do it that way. The other question that, you might, and I don't know if you talked to George about it or not, there is some language in the statute that says that the employer has to notify you of when they're going to do it, and that doesn't start until they notify you, right? So if 2 weeks go by and you're out because you're in the hospital with a leg injury or an arm injury or whatever it is, and then 2 weeks later they say, oh, by the way, we're running your FMLA at the same time, I think those first 2 weeks are excluded from that. It starts when they give you notice. That I haven't analyzed the case of whether if you read the policy and then you're familiar with the policy and you know that the policy says that it's going to start from day one, is that enough to give you notice?
Well, I've never seen a policy. There's no policy in the police department
Yeah.
that talks about that.
So I would definitely look at that.
If the city hall has a policy, I've never seen it.
Yeah. So they might have a employee handbook or a manual or something that they give to anybody. So absent a county-wide policy, generally it's at the employee's option to substitute or not.
I got a real quick question on it.
Yeah.
Well, I'm like one of these things because we've got several. For your injury and line of duty, it's going to be a workman's comp issue. Basically, it was a shoulder injury. It was more pain than anything. It didn't weaken me. Chief wants to send me home because he knows I'm in pain, which then I have to go on sick leave. I'm saying, no, I'm fine, and yeah, I'm in pain, but it takes a year to go through workman's comp. And
Right.
I'm taking a year's worth of sick time, and then hopefully get some of it back. Would that be a fitness for duty? You'd have to send me for a fitness for duty before they can put me on sick leave at that time.
Yeah, so I think the way the procedure should play out is that if you have medical documentation from your doctor that says, although you're being treated, and this is what your injury is, he feels, or he or she, the doctor, feels that you are capable of performing all the essential functions of your job, that medical documentation is going to stand until there is contradictory medical documentation.
It should be on the city to do that.
Right, so if the city then wants to say, hey, we're going to send you for a fitness for duty for our doctor, I think they can do that. But yes, they would have to send you for an actual evaluation to determine if your doctor says that this is what's going on, your doctor's word is the final word until they have other work. And when I say that's the way that I think the process should work out, it usually doesn't work out that way. And I don't know if you have on-duty injury in your contract or not, but that's why those types of things are important. If it's a fairly minor injury that you feel you could come back within 30 or 60 days, it doesn't make any sense for you to apply to BWC. Then the employer's got to go through if they're going to appeal it, they can appeal it. If it's going to be somebody you're coming back in 30 days, let's just pay him for 30 days. He comes back to work and everything's fine. We don't have to go through all of the administrative procedure. If it's going to be something that's long-term, then you might want to start applying. Obviously, get your application in for BWC early. You want to do it the day that you get injured. A lot of the on-duty injury provisions say that you have to apply for BWC at the time.
This was like 9 months into the injury, and I'm still we were fighting the BWC back and forth and all that.
Yeah. And the BWC process is not fast, especially if the employer files an appeal or tries to appeal some provision of it. Because they're not going to approve, if you need surgery, they're not going to approve surgery until all of that goes through. So it's not a good situation. I mean, it's insurance, basically. But if you can get language in your contract about injury on duty and stuff like that, that's supposed to provide for those short-term injuries or absences, stuff like that. But yeah, I think if you have medical documentation, then I would file the grievance and say that you can't deduct my sick leave because I have the medical documentation. Okay. The other circumstance where FMLA applies is if you, as a female, are pregnant, or as the spouse, your wife is pregnant, and when does FMLA start? Does it start prior to birth? Does it start after birth, or what applies after birth? FMLA doesn't apply pre-birth. So although your wife might need prenatal care or is in the hospital or something like that, I think you would be able to apply sick leave, right, under your contract, because it's an illness or injury to a family member. You can apply for sick leave, take the time off. But the FMLA can't kick in for prenatal type of circumstances. And once the child is born, then your doctor, it's either the female's doctor or if you're the male, that doctor is going to say, well, I think the wife is going to be incapacitated for a period of 6 weeks or 4 weeks, whatever that is. That 4-week period, and we've argued cases, we've arbitrated cases like this. Whatever the doctor says that period of time is, if it's 4 weeks, then 4 weeks is going to be covered by sick leave and the FMLA. What happens after that 4-week period is that you're not going to be able to use sick leave, but you'd have to substitute some other type of leave like vacation or comp time. So you understand what I mean by that? Under the FMLA, you have the right to 12 weeks off to care for a child. And we've argued, hey, if I want to take unpaid after 6 weeks, I can. I still get the 6 weeks. You just got to take it unpaid. So you have the 12 weeks. It's just whether you're going to continue to be on sick leave or some other type of leave, or it's going to be unpaid at that point. Does everybody understand what I mean by that?
Real quick on the FMLA, running concurrent, there is a neighboring city who they had 2 employees on light duty due to an injury. And at the end of the 12 weeks, the city administrator has said, and they're on light duty, working in the office, at the end of the 12 weeks, if they have not been treated by BWC or whatever, then they were going to be terminated.
Wow.
And that has not gone through the courts yet, but they have threatened 2 of their employees. I didn't know what your 2 cents on that is, because they're working, technically, they're in the detective bureau, no kind of badge.
Right.
But they've been put on FMLA while they're on light duty.
So, and under those circumstances, I think the FMLA is sort of secondary at that point, right? I mean, you could have a potential BWC retaliation claim. So if they have an attorney that's filed the BWC claim for them, I would say, hey, this is what they're threatening to do. Under the BWC, you have the transitional work program, and I think that only lasts for a certain period of time. and what happens after that. But certainly you might have a potential BWC retaliation claim. But again, I don't think that they can just terminate you if it's determined to be some type of
sufficient sick time past that 12 weeks.
Yeah, so I think it would be a grievance also under the collective bargaining agreement, right? I have sick leave, it's an ongoing injury or illness, I get to use my sick leave for that period. So it could be workers' comp claim, could be a grievance, and if it's a disability, something that's preventing you from performing your duties, you could also have a potential disability claim as well. So most of my experience, I'm not saying that the employers always do it right, but most of them don't want to get involved in some type of heavy civil litigation about those types of issues. So, Yvonne or myself, we'd go out and try and work with the administration to say, let's figure out the plan going forward. And if we have to put that in some type of an agreement, then we'll do that. You're going to use sick leave until now. Maybe we put you on disability leave at then, and so we try and work all that stuff out ahead of time.
Did you have a question?
Running it through my head, maybe you addressed it, I missed it, but he was saying that they were running FMLA and light duty.
Yep. They're kind of the guinea pig. I'm in Franklin County, and they're kind of testing this out. It's a bigger city. It's trying this, and they're on the clock.
Mm-hmm.
And it's kind of like other cities are like, all of us other officers are kind of looking going, that happens there, it'll spread like wildfire.
Yeah, so the FMLA can run concurrently with like an on-duty injury leave, like a sick leave and that kind of.
They're on light duty.
Yeah, so
sitting in the detective bureau, typing in something in the computer, so
Right.
they're being paid.
Yeah, so
And they're being put on FMLA while they're working in that office.
so if you're working and getting paid, you're not using sick leave, you're not exhausting your FMLA leave.
Right.
So I think I would look at that case. I mean, I think we would look at that
When we
case.
heard that, it was like, oh, this could be interesting.
Yeah.
And this is their city administrator. This isn't the chief of police or anything. Their city administrator,
Yeah,
he's
sure.
threatened a couple of them. We've already been told about this.
Yeah, it'd be an interesting outcome. I don't think they can do it. That's my opinion, but.
Well, I hope they can.
And the other thing on the FMLA is it doesn't have to be consecutive time off. They have a recurring or an intermittent leave. So if you have some type of illness that reoccurs every month or every other month or something like that, that FMLA is going to apply during, or you can, when you call in, say, hey, I'm having a recurring incident of whatever this is. I'm going to take FMLA. You can take FMLA for that period. So it doesn't have to be all consecutive right in a row.
Now, the flip side of that, you're on injury leave, so you're not on light duty. And again, okay, I have 2,400 hours of sick time. That 12 weeks, after the 12 weeks, that same city has now said, at the end of the 12 weeks, you're not guaranteed after that.
Yeah.
You'll still be able to use your sick time. Why get it if you're not able to use it after that?
Right. So and I think that's a contractual issue, right? The contract says I get so much sick leave, I can use it for this reason. I get to use it until I exhaust it. That would be my position.
The other test balloon that they're throwing out there.
Yeah. No, I don't. The purpose of the FMLA was really not to apply to public sector employees. It was really intended for private sector employees that don't have a big bank of sick leave or might only have a week or two of vacation. They get ill or injured, they exhaust their 2 weeks of vacation and they're fired at that point. So it was really intended to sort of give this 12-week period for people to recover and be able to come back to work. And a lot of our collective bargaining agreements are going to have better benefits than what the FMLA applies. But just because they're deducting the FMLA at the same time, if you have 2,400 hours of sick leave, the sick leave to me is contractual, and that's what they have to abide by.
Because a friend of mine's a sergeant, that their administrator's stance on it is, you're only guaranteed 12 weeks. At the end of the 12 weeks, and it's like,
Right, for purposes of the statute. But you can't ignore the collective bargaining agreement.
I didn't know if that was something new that they're trying, because it used to be what the 12 weeks was, like you just said, the end of the sick time was supposed to be that extra balloon of safety, and now they're running concurrent.
Right. Yeah, no, I think the sick leave provision under the contract still applies. That has separate and independent of the FMLA potential claim. All the FMLA says is that they can't interfere or restrain your use of the FMLA. So, you know, it would not be an FMLA violation, that's fine, but it's still a contractual violation.
How much time off would you use before they would require you to start with the FMLA? I've never been clear on that, and I've never been clear on if you are FMLA and you're using it daily or weekly and you call in and give me an FMLA day, day, are they assuming that it's because of this injury? Are they allowed to ask you if it's for this reason, like they require you to give a reason for sick time usage? Those questions I've not ever been clear on.
Sure. So the FMLA can start from day one from any what they consider to be qualifying incident. And you have to look at the statute. I mean, there's...
And actually, I have it. It states that the 12 work weeks of leave in a 12-month period can be for the birth of a child, and the care for a newborn child within 1 year of birth, the placement with the employee of a child for adoption or foster care, to care for the employee's spouse, child, or parent who has a serious health condition, and a serious health condition that makes the employee unable to perform the essential functions of his or her job.
And when you know, sort of analyze, when they have the administrative portion of that, generally what, you know, you have to be under care, medical care. So because you get the flu, let's say you get the flu and you're out for 4 days. Let's say you have the flu and you're out for 2 days, right? 2 days doesn't apply. The FMLA doesn't apply. If you're out for 4 days or more and you're under medical care, it does apply. Generally, it's anything of 3 days or more, and you're receiving medical treatment or some type of care for that. But I think most employers are going to look at it and say, hey, if you're out for 4 days, we're going to use that FMLA for those 4 days starting from day one. So they can start it from day one if it's a qualifying incident. If it's a broken arm, obviously that's going to apply. You know, if it's some type of surgery or illness you're going to be out for several weeks, and you need medical care for all that kind of stuff, all of that is going to apply from day one. On the recurring side, so generally they can ask for the reason for the sick leave. You know, I'm a retired firefighter, and we always used to get into a debate about this because you have a chief that says, well, I want to know why you're out. And, you know, you have to bring in all this medical documentation and stuff like that. And then we'd get people that say, no, I don't. I'm not giving you any information. You know, why you sort of get bogged down into the, you know, who's fighting who and why and all that kind of stuff. I think generally speaking, if you call in sick and the employer says, well, is it illness or injury to yourself or a family member, I think they can ask that. They can't ask you, you know, do you have some type of cancer? Do you have, you know, whatever the cause of the illness is or the injury. You know, I think that's a little more dicey, and I don't know if they can ask that. But if you're calling in, you say, hey, I'm calling in because of, you know, I have migraines. I have FMLA on paperwork for migraines. You don't have to tell them all of that. I'm just saying, if you previously have FMLA on file for the migraine, and you call in and say, hey, I'm taking time off for a migraine, that could be an FMLA day, basically. And so over the year period, they're going to start to aggregate all of these different FMLA things to see how much time you have left when you get to, you know, some point later in the year. And the year period is a rolling year. It's not a calendar year. So if you used 12 weeks on September 1st, when your next September 1st comes, that starts to fall off. So you'll start to accumulate more FMLA at that point. And you have to recertify every year. I get a lot of those questions. Well, I had FMLA on file from 2016. Well, you have to certify every year. You have to refile the paperwork for that illness or injury. And if you have separate illnesses or injuries, you have to file separate FMLA paperwork for each one of the different ones. What they considered a rolling calendar year, yeah. Anything else on the FMLA? Yeah.
It's not so much FMLA, but you covered it a little bit earlier. Just like you were talking specific reasons. We have a thing about excused and unexcused absences doctors know. We have a couple people that all see the same doctor.
Mhm.
His note says, saw this patient on Tuesday, he's off till Friday. That's not good enough. I want to know why you're off from Tuesday. And we've given this argument every time.
Mm-hmm.
Where's the point where you have to tell them what the 3 days before, when it's not a long term, it's only 2 days, or like you said, you got the flu. Does he need to know I had the flu, or does he just need to know I saw a doctor that said I can't work?
Right. Well,
Depends if you're like at the 3 days or more.
yeah, my best answer is it depends.
I mean, we have to literally every single note, but it doesn't
Yeah.
say why. It doesn't have to say why. But it's
And I think
1, 2, or 3 days.
I think there is a case. It's not from Ohio or this area, but one of the areas where I've heard that GINA applies is that they can't ask for medical information that could potentially trigger that GINA, So I don't know whether that case went as far to say that the employer cannot ask the reason. But I think they, if it's just the flu and you say, hey, it's the flu,
If they ask, you have to tell them, or they have to say.
well, they can compel you to say, right? And if you don't, you're going to be subject to insubordination or whatever. The question is, would you have some type of cause of action after that, right?
So in theory, if they ask you should tell them.
I think if they order you to, I think you have to comply with that, unless it's been determined to be unlawful. So we'd have to determine that that was an unlawful order.
And it's really not that big a deal, but it's amazing how something that little becomes
No, I know.
a big deal.
It does, and that's what I said when I was at the fire department. We got into this all the time. The chief would say, "Well, why?" And we'd have employees that say, "I'm not telling you." And they never came to, a grievance or some type of lawsuit or anything like that. But there's that inherent tension between management and employees. For me, if I had the flu, I would just say I had the flu, right? It wasn't a big deal,
If it's not that big of a deal, then just, is it really worth?
right?
And I think it's become because it became a bit, now it becomes a bigger deal. I'm not going to tell him absolutely.
Right.
This is law.
Exactly. That's the who's going to win the argument, right?
Yeah.
But I think anything. So if it's more than what Yvonne said, if it's more than 3 days, if it's an FMLA qualifying event, then you have to either fill out the paperwork, or when you fill out the paperwork, that doctor has to specify what the reason for it was. Okay. Any other questions about that? And it's surprising, you think the FMLA is fairly easy to understand, but we get calls every day, and there's a lot of questions I don't know. I'm like, I got to go look it up. I got to find a case that says, what this means and all that kind of stuff. It happens all the time, so there's always new things happening.
Kind of just according to you, it seems that you would take that to an advisory board. You guys would meet up and wondering what they can ask. You guys can come up with a collective opinion based on the law and stuff like that. But if it's that much of a gray area, we have it under wraps. We just look at it on our CBA that the employee can ask where the nature of the so that might be something that look at closing in the CBA whenever you come around.
Yeah, and so for purposes of the video, the question was, is if there's language in the CBA that the employer can ask, or should we try and negotiate language that eliminates that? Yeah, all of this is going to be controlled by the collective bargaining agreement. So the more that you can negotiate and get language in there as to what the employee's requirements are, that's going to be all the better. It's obviously difficult to do because employers don't want to, give up that right. But yeah, anything that's in the collective bargaining agreement is going to apply, and the more you can do, the better.
Should the CBA something in it that says that we will follow an FMLA policy? Or, I mean, if they say we don't have a policy, we fall back on the FMLA, whatever.
Yeah.
Because personally, I've never seen a policy, so.
So
Something you would want in the CBA also?
a lot of our contracts have, generally, broad language that says that the employer will follow the FMLA. To me, I don't think that needs to be in the collective bargaining agreement, although it would trigger a grievance that would be subject to arbitration as compared to potentially having to go to civil court. So you understand the difference between the two. If there's something in the collective bargaining agreement, we have a right to file the grievance to enforce the collective bargaining agreement. So if the language says they'll follow the FMLA and they don't follow the FMLA, then we'd file a grievance and potentially go to arbitration and have the arbitrator to decide that case. The downside to that, though, is that a court may look at that and say, you cannot file a civil case. You have to go through the grievance and arbitration process. There's generally a standard out there that courts will say that if something is covered by a collective bargaining agreement, the courts, civil courts, don't have jurisdiction to hear those claims. Now, that's not simple. There's a lot of gray area when you're talking about federal regulation about what you can and what you can't do. Like EEOC claims, you can't force, I guess, somebody to not file an EEOC case, but it creates a whole gray area.
Or sometimes the contracts will say, if this should happen, then the bereavement or employee will have the option to file an EEOC claim.
Right. Or it might say you cannot file, if you file a grievance, you cannot file an EEOC claim. So it creates a very gray area. I guess my only, you'd have to work with the attorney in that jurisdiction. If it's not in the collective bargaining agreement, the FMLA still applies, though. So, then you would fall back on the federal regulation and all the case law and everything that interprets the FMLA. You're still going to get the benefits. It just would not be something that you would get through the collective bargaining agreement. You know what I mean?
Yep.
Okay. Yeah.
Ours has language that basically says that if you go to any other avenue to satisfy your grievance, then you forfeit the collective bargaining.
Yeah. So if you filed an EEOC claim, you would not be also able to go through the grievance and arbitration process.
So, an EEOC claim has a limit of what, so many days.
120 days.
Yeah.
So, if your situation gets hung up in a grievance, then you might miss on the EEOC. So, but yeah, with EEOC, you have to file it either through the state or federal or both.
Right.
And then hire an attorney. And it's all civil or.
Yeah. So the EEOC. So EEOC is the federal regulation that deals with that. Ohio has the OCRC, the Ohio Civil Rights Commission, which mirrors essentially that same procedure. And what ends up happening is that you would file a claim with either the state or the federal government. They will do. You don't have to have an attorney for that process.
Right.
They will do the investigation. Ultimately, they will determine whether there is probable cause to believe something happened or there's no probable cause. If you get a probable cause finding, the government will pick up the case from that point and prosecute it. If you get a no probable cause finding, then you would have to go out and hire your own attorney to file some type of civil lawsuit. The other potentially major difference is that under the collective bargaining agreement, you're going to be limited to a contractual violation. So if there's something that you were out money or some type of compensatory damages, that kind of stuff, you're going to be limited to the contractual damages under the contract. In the civil side, you could potentially get punitive damages. You get your attorney's fees paid and that kind of stuff. So you're going to have a lot broader remedial power through the civil courts than you would through the collective bargaining agreement. So I know that was probably a more complicated answer, but there are reasons to do both. And really, I would just talk to the OPBA attorney about in that jurisdiction, maybe this one way is a better way to go than another.
Yeah, but is there, I mean, would you recommend us getting something in our contract, like getting that, like changed so that you would be able to do both? Because, I mean, to me, that's crazy to be able to limit somebody to be able to do something about a situation, and not be able to fall under what your contract provides too.
Yeah. You know, and that it's sort of a shifting issue. Several years ago, this may have been back in the 2000s maybe, but there was a federal case called Penn Plaza that said if your collective bargaining agreement specifically says that you are hereby waiving any EEOC or Title VII claims, and that would all go through the grievance and arbitration process, you are limited to that process. You could not file a separate claim. I think the courts have sort of not backed off of that, but a lot of collective bargaining agreements don't have that specific language. It doesn't say, I am hereby waiving my right to blah, blah, blah. It generally just says you either file an EEOC or you file a grievance. So can we abolish your EEOC claims through the collective bargaining agreement? I think that's still a gray area. To me, I think it's just either cleaner to allow both avenue or have an absence of language, right? In the absence of language, you could do both. All right, what do you think, Yvonne?
Yeah, I mean, I think depending on grievances, you have a shorter sometimes window to file a grievance though.
Mhm.
But obviously with an EEOC claim, you have that larger window to file something. So if you miss that deadline, you might be barred even doing the grievance. So,
Yeah, that's a good point.
you know, sometimes you have to file a grievance within 5 days. You know, do you happen to miss that time frame? I mean, you still have that EEOC option. You have 120 days. So sometimes a little bit more time is more helpful, depending on the circumstances. I would
Right,
think.
sure. Yeah, no, it's not an easy situation. It would be time for a break. I'm going to just talk for a few more minutes real quickly about the ADA. So in your packet of information is information on the ADA. And essentially what the ADA is that if you have a disability that's either been determined by a doctor to be a disability or it's been recognized by the employer to be a disability, you have certain rights. They can't discriminate against you, they can't fire you, they can't do a bunch of different things based on the disability. The question is whether the disability interferes with your ability to perform the essential functions of your job, right? So if you're a right-handed shooter and you have something happens to your right hand, you can't shoot anymore, is that an interference with your ability to do your job? Probably yes. And they don't have to keep you on because you can't fulfill the basic function of the job. But you have, again, under the Ohio Revised Code and the Administrative Code, you could file potential disability with the state pension if you're in PERS or if you're in police and fire. There is disability provisions there. Again, we don't file disabilities, but we would have somebody that we could refer you to that does do those types of claims. And that's a whole nother avenue that you have to go down. But in the statute information that I gave you, it talks about an involuntary disability separation. If you go to your doctor and your doctor says he can't do the job, he or she can't do the job, or you were previously sent by your employer for a fitness for duty and that doctor has said you can't do your job, you go to your doctor and that doctor says you can't do your job, there's no medical dispute that you're not going to be able to continue to perform your job, they can issue what they call an involuntary disability separation notice that says, as of this date, we're going to separate you from employment. You have the right to a hearing. If there is contesting medical documentation, you have the right to a hearing to come and determine, first of all, whether you are disabled and you can't work or not. But most of the time, most of the ones that I deal with, both doctors are saying can't do it. There's no dispute about it medically. So we usually end up waiving the hearing. They'll put you on a disability as of a particular date, which means, like I said before, you're not on payroll anymore, you're not an employee. But if you recover within the 2-year period, you can apply to go back to your job as if you had never left, back to the position that you held prior to leaving. So it doesn't mean you're being fired. It just means that if, within the next year you rehabilitate and you're able to come back to work and all the doctors say, yeah, okay, you can go back to work at that point. And there's a...
We've been able to negotiate, like the one from 2 years ago, we actually negotiated with the employer to allow the employee to exhaust all of their sick time prior to the separation. So that way it was almost like the clock started after they exhausted all of their sick time. So we can always try to negotiate something with the employer to benefit the employee.
Yeah.
And if it's mutual and if the person's going to be disabled and wants disability benefits, I've worked with employers closely to make sure the paperwork gets to them that day. They sign it, fill it out, fax it back to speed up the process. So sometimes the employer is very helpful in that regard to help the employee get their benefits. That's happened actually quite a bit this year for me. So.
Yeah, and you may be disabled for purposes of working, but you still got to file the disability paperwork if you want to go on the police and fire or PERS disability system. You have to file the application, you have to go through their procedure in order to qualify for the disability. But like Yvonne said, and this happens a lot, we usually end up trying to negotiate, some type of an agreement. The employee is going to stay on sick leave. The other question is what happens to your medical benefits? If you are the provider for the health care and you're providing for your family or your dependents or any number of people, you go off of payroll, you no longer have health care benefits. So how are you going to get health care benefits is a big question going forward. We've been able to negotiate sometimes that says, the employer will continue to pay or will cover your COBRA costs for a period of a month or two. It's not going to be extended, it's not going to go on forever. But we try and at least get some benefit because the disability process is going to take about 90 to 120 days. So once you get on the state's disability program, your health care benefits will go retroactive back to the date of when you left employment. But during that 90 to 120 day period, you might not have specific coverage. So we try and bridge the gap as best we can. But there is options out there. So, but the medical issue is a growing issue for everybody, and we get a lot of calls about it. So, any other questions?
How does your FMLA unpaid time affect your continuing health care coverage? I know we have someone using FMLA now, and it's come up, she has to pay part of her insurance, or...
If she's on unpaid, then sometimes the employer will tell you like what the employee portion is, and sometimes they can submit it. I had that in one of my groups where the administration told me how much the employee portion was, and they just submitted a check, so that way they still maintain the benefits.
So if you're not getting paid for your 80 hours, then that's customary, you would have to pay your...
I don't know. I've had it happen in groups where I've had employees just submit to either a city or a township and say, here's my share, and they actually continued it, but that was something that we helped negotiate too, so.
Yeah, I think they have to continue your coverage. The question is who pays, basically. And usually most employers, and I think most insurance companies are this way, and don't hold me to this, but all of the employers that I've dealt with anyway, usually they say if you're on payroll as of the first of the month, your health care will continue until the end of that month. So, if you can somehow or another get to your sick leave to November 2nd, you're going to be covered on your health care all the way through November.
But you may have to pay for your employee's share for that second payroll, though.
Well, once your premium is paid, so if it's been paid on the first of the month, then you're going to be covered for the rest of that month. The question would be on December 1st, if you have no leave, you're off of payroll, what's going to happen to your health care benefits at that point? And those are the kinds of things that we can usually negotiate and say, look, we'll pay the employee portion or something like that if you can cover her under COBRA. Or I think under the FMLA, they have to continue the coverage. It's just a question of who's paying, basically. But we work on those on a case-by-case basis, so give us a call if something comes up.
Is that something that's in the FMLA policy?
I don't know if it's required. I mean, generally speaking, every employer should have a policy that tells you when it's going to apply, what's going to happen, what are your benefits going to be. So generally, yes. I can't say that all employers do, though. Okay, we'll take a couple minutes break. Maybe 10 minutes. We'll come back about 5 after. Thanks.